Hello, I'm Christopher Anderson, and today I will be talking about libel in fiction. First, we need to understand what libel is. And Cornell Law School and Legal Information Institute defines libel as a method of defamation expressed by print, writing, pictures, signs, effigies, or any communication embodied in physical form that is injurious to a person's reputation, exposes a person to public hatred, contempt, or ridicule, or injures a person in his or her business or profession. So, how does libel in fiction happen? Libel in fiction happens when a story includes a character that accurately resembles a real person. This can be libelous if the character does negative, untrue things that the viewer can relate and cause harm to the real person the character is based on. Pring vs. Penthouse International is a good case to understand how someone finds the grounds to file a suit for libel in fiction and one way that libel in fiction is disproven. In the case Pring vs. Penthouse International, they had to find the actual facts and the actual conduct of the plaintiff. The actual facts were well established, so the court had to find the actual conduct. The issue at hand was Penthouse released an article about a Miss America pageant contestant, Miss Wyoming, and that the real Miss Wyoming, Kimberly Jane Pring, found 3 incidents to be libelous and causing defamation. The first incident was Miss Wyoming was waiting for her turn to perform her baton twirling when she thinks about a time where she performed fellatio on a football player and he starts levitating. The second incident is that she starts performing her baton twirling and does a fellatio-like act on the baton. And the third incident is that the finalists are being crowned and Miss Wyoming performs fellatio on her coach and he starts levitating while the cameras focus on them. The court ruled in favor of Penthouse International because for the story to be defamatory, it has to be possible and the acts in the story were impossible and simply a rhetorical hyperbole. According to Gregory and Sarno, in the article Libel or Slander, Defamation by Statement Made in Jest, published 1983, another reason the court ruled in favor of the defense was that the name of the Miss Wyoming contestant in the Penthouse article was Charlene instead of Kimberly Jane Pring. This case of libel in fiction causing defamation displays that rhetorical hyperbole of impossible acts can be protected speech for writers. This case also shows how a fictional work can be targeted for libel and defamation even though it is a fictional story. Another case necessary to understand libel is New York Times vs. Sullivan, because this case produced the test that is used to determine libel. In this case, the New York Times posted an advertisement in the paper that was posted by a group of ministers involved in the civil rights movement asking for donations to help Martin Luther King Jr. and to shed light on how King Jr. has been treated by the Alabama Police Department. The issue that arose from this advertisement was that the commissioner of Montgomery, Alabama, felt that even though he was not mentioned in the advertisement, that because the advertisement exposed the police force for the mistreatment they carried out, that it reflected on him. Sullivan sued the New York Times for $500,000 and won at the Alabama Supreme Court level, but when it was taken to the United States Supreme Court, they ruled in favor of the New York Times because there was no proof that the New York Times and the ministers had actual malice in the advertisement. This is where the case produced the actual malice test. According to Kaufman in the article Press, Privacy, and Malice, Reflections on New York v. Sullivan, published 1984, the actual malice test is used to determine libel because it states for libel to be found, the press responsible must have knowingly and willingly published false information that they knew would do harm to a person it is about. This applies to this case because the New York Times and the group of ministers that just posted an ad asking for money and gave information about what has happened to the civil rights activists to the best of their knowledge. This means that they had no actual malice in posting this advertisement. Now the question at hand is, what is the criteria used in determining actual malice? According to the article, Clear and Convincing, Libel, Fiction, and the Law of Defamation, published by the Yale Law Journal 1983, determining actual malice in cases requires the plaintiff to prove that the statements made were of and concerning the plaintiff. The article continues to state that the of and concerning note of libel common law is necessary because for the statement to be libel, it must be portraying the plaintiff in a recognizable way. The of and concerning note has three criteria that must be met: unmistakability, individuality, and conviction. The unmistakability criteria means that the statement made was about the plaintiff and no one else. The individuality criteria means that the statement made must refer to a specific individual rather than a broad group or general statement. These first two criteria are used to define the clarity of the libelous statement in reference to the plaintiff. Lastly, the statement must meet the conviction criteria. The conviction criteria is that the statement made must be believable to the audience for it to create legally compensable damage to the plaintiff's reputation. We can see in the case of Sullivan v. New York Times that none of the three criteria were met by the plaintiff. The plaintiff could not prove unmistakability because he was never mentioned by name or described in a manner that was describing him. He could not prove individuality because the advertisements in the paper referred to a broad group and made general statements. Lastly, the plaintiff could not prove the conviction criteria because the advertisement the belief made in the audience did not inspire a change of belief specific to the plaintiff. Therefore, this case is important to understand the history of libel in America and how the Supreme Court determined how to test for libel. This case was crucial for the understanding of libel and how to determine whether or not someone has published a libelous work. Now, a well-known recent case that displays how libel can be found in a fictional work is the case of Green v. Paramount Pictures. The issue that caused this case was that Jordan Belfort, a co-founder of Stratton Oakmont, wrote a memoir about his times on Wall Street, where he engaged in many illegal and immoral activities, and he wrote a memoir based on this period of his life that was adapted into a movie. In this movie, there is a character, Nikki Koskov, that Andrew Green, the company's director, general counsel, and head of corporate finance, claimed was based on him and defamed him even though the character was based off three different individuals. Andrew Green claims that in the movie, Nikki Koskov is clearly representing him, and when Koskov engages in all sorts of illegal and immoral activities, it causes damages to Green. Green had to prove that Paramount Pictures knowingly and willingly made defamatory statements about him and with disregard for the truth. The court ruled in favor of Paramount Pictures because Green failed to prove that Paramount Pictures knowingly and willingly made defamatory statements about him with disregard for the truth. There were three reasons that the court cited for making their judgment. First was that Paramount Pictures went through many steps to ensure that none of the facts were libelous and none of the characters would easily identify one person. They did this by talking to the real people in the memoir, reviewing the book and news, and by combining the people and the true events into one character so that no one was clearly identifiable. The second reason was that no reasonable viewer would believe that Koskov was depicting Andrew Green. This was made evident because there was no character named Andrew Green or his nickname Wigwam. Paramount also made sure that the Koskov character was representing three different people, and that in the movie, Koskov was a broker who worked on the trading floor. Lastly, the film used a disclaimer that stated the characters were fictionalized. In summary, it was found that Paramount Pictures did not act with actual malice towards Andrew Green. This case is an excellent example of how a person who is seen as a public figure can find a work of fiction to be libelous. This case also shows the process that a court undergoes to determine whether or not a person has been defamed by libel in fiction. This case also displayed how the actual malice test is used to determine libel in fiction. This case is also interesting because it takes into account the case that was mentioned earlier, Pring vs. Penthouse International, and how it was applied to Green vs. Paramount Pictures. The Pring vs. Penthouse International case was applied because, according to Roy S. Gutterman's Liable NAAAHT, the mockumentary, Litigation Liability and the First Amendment in the works of Sacha Baron Cohen, published 2022. In the case, the courts found that no reasonable reader or viewer would understand the content as reasonably believable. This was seen in Green vs. Paramount Pictures, when the court ruled that no viewer would reasonably believe that Andrew Green was portrayed by Nikki Koskoff in the movie Wolf of Wall Street. Thank you for your time, and these are my citations.